Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about the Illinois arrest and charging process in criminal law. So what happens if you're arrested? What rights do you have? What's a warrant, and what is the process after you're arrested? So let's start with what rights you have. First of all, you have a right to an attorney, and you can get a free attorney. And this is something that you should certainly exercise because that attorney will explain the rest of your rights to you. Some of the other important rights are the right to remain silent during the investigation. If you watch TV, you know that anything you say or do can be used against you, and you don't have to talk. You don't have to testify against yourself in court either. You have a right to a bond hearing, which will allow you, if the court decides that it's appropriate, allow you to leave pending trial. You have the right to be informed of the evidence and witness statements against you. If you are convicted, you have the right to appeal that conviction. Finally, you have the right to refuse DNA samples unless ordered to do so by the local magistrate. So, be aware of those rights. The most important thing you can do is be silent until you have your attorney present, and then your attorney can guide the process from there. So next, let's talk about what a warrant is. A warrant is an order from a court that authorizes a police officer to make an arrest, search a specific location, or perform some other specific action. In order to get a warrant issued, the officer has to file a complaint with a magistrate, basically showing probable cause for the arrest or action or search that the police officer is seeking to have done. And the magistrate will review the complaint and see if there's reasonable cause to believe that the individual in question has committed the offense that they're accused of. If there is reasonable, probable cause, then the court will issue a warrant, and that authorizes the officer to make the arrest, search the location, or perform the other specific action. So officers can make arrests without warrants. They can also perform stop and frisks. What's a stop and frisk? A stop and frisk happens when an officer reasonably believes that an individual may have committed a crime or may be about to commit a crime. A stop and frisk has to be for a brief period of time, and the officer has the right to ask questions of the individual. Now remember, the individual that is being stopped and frisked has the right to remain silent. The officer has the right to pat down the individual if the officer has reasonable cause to believe that the officer's in danger. So that's the stop and frisk. Next, let's talk about what happens if the officer has reason to believe that you've committed an offense. So after the stop and frisk, the officer can make an arrest if they have reason to believe that you've committed a crime, or that you're likely to commit a crime. So at this point, the officer has to let you know about your rights. Again, what you've seen on TV, the Miranda rights. The officer then will have the option after the arrest to release you and request that the state's attorney charge you or formally charge you with crime at that time. You then have the option to know what charges are being brought against you, or the right to know what charges are being brought against you. So what are criminal charges? Criminal charges are formal accusations made against a criminal defendant. Once these charges are made, if they're felony charges, the prosecutor has the option to either approve the charges and move forward, decline the charges, or basically send the charges back to the police department and ask the police department to gather more evidence and reinstitute the charge if the prosecutor thinks the evidence is weak. Also, if the evidence is too weak to sustain a felony charge, the prosecutor may basically reduce the charge to a misdemeanor. So after you're charged, you may be able to, you have a right to a bond hearing, and based on what the court decides, you may have the right to pay a bond in order to be released from custody pending trial. So a bond is a payment that you make, basically a deposit to make sure that you're going to show up at your trial date. For felony charges, the magistrate has the discretion on what the bond amount is going to be. For misdemeanor charges, these are usually set by statute. So you basically have a hearing, find out what the bond amount is going to be, and you have the option to pay that amount. If you show up at your trial date, you can get that payment back. If you skip the trial date, then that's basically an incentive for you to show up. So if you skip the trial date, then you forfeit your bond. So that's the basics you need to know about the arrest and charging process. If you have any questions, you can call our office at 630-324-66 888-878-6666 or leave a comment in the comment section. Thanks so much for listening.
Thanks for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit makingrealestatefun.com for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation. Thanks for watching.